Buenas tardes. Vamos a dar comienzo al último panel del día y de estas jornadas también. Marcación personal, protección de la marca personal en el deporte, que estará...
Okay, so the personal brand in sports, moderated by Noelle, and with the presence of Miguel, Fernanda, and Felipe. We thank him for his presence. And so we'll play the video, and then Noelle will moderate. Miguel Muñoz-Lopez and Associates PLLC, USA.
Moderadora.
Moderator, Noelle, Jeanneret, Muñoz, Jeanneret, Alvarez, and Company, Chile. Hello, good afternoon. How are you? I'm a bit mute when I have a microphone. Thank you for being here in this last panel in ASIPI Medellín. Take the opportunity to thank the Executive Committee and the Association for inviting us to speak now. I won't be speaking, I'm just coordinating. And we are honored to participate. I feel honored to be here with great professionals who have been introduced already, but I'll introduce them again. Felipe Restrepo, Miguel Muñoz from Colombia, Brazil, and the United States, respectively. Felipe is a lawyer with a postgraduate in law and sports management. He's an expert on sports law, currently working as the legal director of the Deportivo Cali Association, and is a representative or is a professor in Universidad del Rosario. He has over 10 years of experience in international football competitions with FIFA, CONMEBOL, the Colombian Soccer Federation. He's participated, among others, in World Cups, FIFA World Cups in South Africa 2010 and Brazil 2014, the World Cups of clubs, FIFA 2014, Japan 2016, Olympic tournaments in 2016, the Copa America of Brazil in Brazil in 2019. Fernanda is here from Brazil. She leads the marketing law and entertainment law, and has over 20 years of experience in local practice and private at a national and international level, advising clients on commercial and strategic subjects, marketing, publicity, digital media, authors' rights, new and emerging technologies, and metaverse and NFTs. She has a master's in intellectual property law, technology, and commerce of Franklin Pierce Law Center 2003. Is faculty or is able to exercise in the United States, in the District of Columbia and Virginia, in addition to Brazil. Fernanda is also a member of the Ethics Committee at Kasznar in Brazil. Finally, last but not least, from the United States, Miguel, you all know him. He's a friend from an ASIPI, a member of the Brands Committee, very active and beloved to many of us. So over 15 years of experience accompanying multinational companies, entrepreneurs, and celebrities. The University of Raymond Jewell in Barcelona and the University of Fordham in New York, and centers his practice in the protection and defense of commercial brands and all of the transactional factors related to these subjects. He is consigned to the New York Bar, a member of the Committee for Brands of ASIPI Inca and IVA with the International Bar Association, and participates frequently as a speaker in conferences and international forums on intellectual property. Felipe, Fernanda, and Miguel are here to talk to us about personal brands, or protection of personal brand in sports. And despite what this suggests, we won't talk about personal brands, but we will talk a bit about distinction, about how to become known and use other elements to become known, and that it's people themselves. And we'll begin with Felipe, and I asked Felipe, what are we talking about exactly? What are we referring to when... And how does this begin to gain traction, and how does this evolve throughout time? Now, to begin, what we're talking about here is, of course, image rights and the management of brand in the sports world. And to me, to give some context on how this begins, there isn't a big bang or a single origin, but I do think there is a crucial year, at least from the football perspective, and it's 1974. 1974 is the year in which João Belange, Brazilian, wins elections to become president of FIFA, and has an aggressive perspective from a approach from a commercial perspective, very much focused on sports, and it becomes a business involving the largest brands of the world, mainly Adidas and Coca-Cola, with the development of football competitions to take them not just to Europe and South America, but toward Africa. And what we're seeing, the expansion of FIFA's competitions to all parts of the world, attracting the money of the brands, protecting the brands so that the product could become something truly identifiable. And so in 1974, football begins to change in parallel, and the World Cup organized that year, although these measures had not taken effect yet, intending to that the President and General Secretary wanted to implement. Johan Cruyff, who was probably the best player of the time from Holland, very recognized, had already incurred in a contract of personal sponsorship with the Puma brand. So the rights of image that is recognized, or right to publicity that is recognized for every person, we understand that it's inherent to the individual, and there are certain legal and constitutional protections. This person, this player, Puma, joins him, seeing great potential. And at the same time that this successful relationship is in development between Puma and Johan Cruyff, on the other hand, Adidas, a great rival and competitor of Puma at the time, although it's a larger brand today, at that time, there hadn't been so much time between the conflict between Rudi and Adolf Dassler, two brothers who set up their companies on two sides of the river in Germany. Rudi Dassler with Puma, and Dassler with Adidas. There was a ferocious battle for establishing their brands in sports competitions. Adidas signs for the first time in history with the Federation of Basque Countries, so that the uniforms for their team was Adidas. And so Johan Cruyff, with a contract with Puma, was going to wear the Adidas colors. And Cruyff, with all of his influence and all of his power, sits to negotiate with the federations and says, yes, the uniform is Adidas, but the head, the person who's there, is me, and I will not wear that brand. And equal treatment was given to all players except him. And so the federation concedes this, and you can see the shirt, the uniform, it was all special. It was made especially for him with 2 stripes and not 3, without the Adidas logo, so that he wasn't campaigning for Adidas. And this, Puma continued to capitalize on this for a long time after, because they could use the images of the World Cup and the selection with their best team without the emblems of their main rival. So it was probably the first great case in which a player enforced his right to publicity and his domain over that personal brand, and the value that the brand gave him in a transcendent manner, because it was in the most important event for the sport. we see this and we might think, well, 1974, a long time has passed. There's a lot that has happened, so much has been learned that this is inconceivable today. But I would have this question. Nowadays, with all of the evolution and the magnitude of contracts with the specific clauses we see today, this today would not happen. Or would it? I'll leave that question open for you, and we'll continue with the panel. Thank you.
Increíble.
Thank you, Felipe. It's really incredible how things evolve and how they crystallize throughout time. Nonetheless, I would like to ask Fernanda, what can you tell us, as well as Miguel, about the current normativity? What's the legal framework?
Thank you.
Sure.
Fernanda.
Would you click for me?
Yes, of course.
So I brought here a few slides to summarize what image rights are covered in Brazil. First is a right that is born out of the Constitution, so it's determined to be a fundamental individual right, granted to every citizen or resident, foreign resident in Brazil. It's a right that is expressly attached to the persona, so it's not only a right in terms of an asset comparing to a trademark right or a patent right, but it's attached to the individual. Would you click for me, please, Noelle? And from that ruling, thank you, that's easier. The civil code, the most recent civil code, established very clearly the principle and the characteristics of this right. And the most interesting one for me, I think, to discuss here is the element of transferability and how non-renounceable the right is. And the reason that's so, I think, relevant to our discussion is because a lot of times the way to contract and to transact on personality rights, image rights in general, is through assignment contract, which technically would be pretty wrong. If it's non-renounceable and non-transferable, the right can never be negotiated as an assignment, but rather as a license. And the impact that this small, quote, small technical issue presents is not only from an IP perspective, but also from a tax perspective. So a lot of times we do see professionals in the sport industry talking about the assignment of image rights, when in fact what the player or the athlete is really doing is temporarily, perhaps exclusively, licensing that right. The civil code also determines that the mere use of one's image without authorization for commercial purpose will automatically generate the duty to indemnify. So that's also very important when you come to counsel clients as to what's the risk of using one's image rights without the proper documents. And we're going to see a couple of cases here where that becomes very clear, the risk. But it's one of those IP rights that is very difficult to clear globally and to have no risk, to have an assessment of no risk, because in Brazil and in most civil law countries, it's a very personal right. It's not an asset, as we're going to see in right of publicity, just making a comparison here. Is that this one? Here we go. So in the 90s, 1998, Brazil passed a law specifically related to sports. It's the first law in the country that primarily focuses on the practice of sports in Brazil. Was passed by the then Minister of Sport, Pelé, so it was nicknamed the Lei Pelé, the 1998 law. And it has been amended a couple of times. And what this law basically talks about is that the athlete has, expressly declares that the athlete has what we would compare to the performance rights in a show, in a theater, or in an artistic show. So it creates a specific legal figure for this performance by the athlete. It's called the arena rights. So when the athlete shows up in a game, in a competition, it's performing a show, if you will, an artistic show, And for that performance, it's entitled to a percentage of the broadcast rights. The team has assigned or has licensed. And most recently, there was a big change in this law, which previously determined that both teams that were playing that specific tournament or game would have the mandate to determine who to license and for how much, obviously that being the most important part. And the recent law, 2021, changed to the mandate home team, which basically gives the small team, soccer teams, the ability to, or teams in general, the ability to negotiate different terms with big players, such as TV broadcasters or social media broadcasters that nowadays exploit more and more commercially the content of soccer. This change is only applicable from the date of the law forward, not back in time, but still it changed a lot how soccer is monetized, especially soccer broadcasting is monetized in Brazil, because it opened a front to a lot of, again, small teams to negotiate these rights. And at the same time, it opened a window for broadcasters, and especially in social media, to also be a player in the field. So,
Thank you, Fernanda. And what about Miguel? ¿Qué nos puedes contar de Estados Unidos?
And about the United States, Miguel, what can you tell us about the United States and this legal structure? Do we also encounter the same problems as the civil countries? Perhaps complementing that an idea you gave us at the beginning of the panel, in the United States you may explore different paths to protect the commercial rights around the image of an athlete. Just as Noelle mentioned, it's not a topic that is exclusive to brands. The branding does allow you to have a measure of protection as the copyrights or this figure that is known as right of publicity. That different to the other doctrines, it's not a discipline which is regulated at a federal level in the United States. It's regulated on behalf of the states through an institute that is emitted by a local Congress or by common law. Sorry, Miguel, you spoke about right of publicity. Is it the same as the image rights? Possibly, but complementing something that Fernanda mentioned. Over here, it attains a particular type of nature. The right of publicity is not a term of intellectual property in the United States. It's a torts doctrine, or it's a civil doctrine over damages and exploitation of the image, the appearance of an individual, which is not exclusive only to athletes or celebrities. So in terms of translation, semantically, we could call it the rights of image, but in legal terms, different to what happens in Brazil, it's not an individual guarantee. It is not within the Constitution. And I would even say the contrary. In the Constitution, we have the most recurrent defense on behalf of third parties to be able to defend yourself against the right of publicity, which is the First Amendment, which is the right of free expression or freedom of speech. So in the Constitution, you don't find the right of publicity. What you find in the Constitution is the counter of the right of publicity and the genesis of this concept. And with this, I want to reinforce the idea that it's not strictly intellectual property. The genesis comes from a case at the beginning of the past century in 1905 in New York. And it is directly linked to that right of privacy. Now, the case, for those of us who have had the opportunity to practice in the United States, that's a case that is shown in school. The case is Robertson versus Colchester. Robertson is a lady who made some portraits of her own image. She was a lady a very beautiful lady with an appearance that of course appealed and grasped the attention of everyone. And the photographer that took these images sold them. He sold them to a company that commercializes what? And when Abigail Robertson finds her image in these bags, she demands and says that her right to maintain private is being violated. And once again, in terms of the redaction of the demand, she received an emotional damage when she saw herself projected in a bag of what? And the Court of New York, the Court of Appealing, rejects the demand. He fails in favor to the company, and this pushes the legislation of New York to omit the first law of the right of publicity. That's where we go into the first institute. But going to the first question, the right of publicity is in essence an economical right. That commercial element must be present so that the individual that is claiming the right can sustain the legal action. And if there is no interchange, I wouldn't call it an interchange, but if we don't have this economical or commercial element or transactional element, we wouldn't be talking about the right of publicity. That's why there are several paths that may be explored in the United States. Sometimes there is a lot of forum shopping depending on where you reside and what rights are at your disposition. You could advance with trademarks. And just as we might all know, this is a much more known subject, but trademarks is more guided to protect the consumer, not the individual. But with this orientation, you can obtain a trademark around your name, so for those products or services that are being commercialized with your name, so you can license it and others. And if it's this path is not authorized, you can go with right of publicity. And with right of publicity, one of the greatest advantage that is granted around the protection, if you reside in a state that is being protected in a statutory way, is that you can go through all the damages. You can go to current damages, criminal damages in most of the entities, and you can also advance around the clawback or the recovery of all the profits that were obtained by the third party that used your image in an authorized way. So there are different paths. Each one of them has a different nature. These are doctrines and legal concepts that are regulated in a different manner. And with this, I want to call, the Line Hamag and other kind of regulations at a federal level that touch topics of copyrights, brandings, and this is perfectly known, but the right of publicity varies from state to state, and you might imagine that which states have developed these institutes that are more composed. Of course, California, because we have those celebrities living there. New York is historically relevant, and Indiana, that is a hub for athletes that are still going through college, and that it's also become a great industry, starting from a case from 2 years ago from the Supreme Court where it's permitted for them to commercialize their image. There are differences of what could happen in other jurisdictions. Thank you very much, Miguel Doser. And
there be like this relationship between derecho de imagen and right of publicity, such as derecho de autor and copyright, for instance, like one being centered on the person?
Yeah, sure. I think that's
like an analogy.
Yeah, a little bit of what we said before, and that's why I wanted to make the introduction as to where it comes from. The image rights come from the Constitution and the articles that establish individual, non-negotiable, stone rights. And when it comes to copyright, it's very similar, comparing copyright and derecho de autor. It's a right of copy. It's a monetary right versus a moral right attached from the author, from the creator to its work. Sure, copyright has some level of moral rights, something more recent, but it's not the same spectrum of individuality between the author and its work in the derecho de autor or derecho de autor and the copyright. So I think that would make that analogy, to compare the two doctrines.
Thank you very much. In Chile, at least, derecho de imagen is not regulated at all. It's It's been developed entirely from case law, and it stems from the Constitution from the right of privacy.
Mm-hmm.
And it's being built entirely by courts.
Mm-hmm.
So we don't even have the constitutional acknowledgement, but the right of privacy.
Mm-hmm.
So, well, it's a similar situation in doctrine as the one in Brazil, of course, but it's very interesting to draw the distinction. Maybe a lot of you know, but at least I didn't know when we started working on this panel. So, so thank you very much for enlightening us. And what about practical cases? What cases can you share in your experience about?
Can you click
this
for me?
topic?
I
Yes,
brought 3 cases here for us to take a
course.
look, and I want to more comment on the practical business impact of it. This is a soccer player, Ebert, sued EA Sports, basically because his image, his persona, his physical characteristic, and even name, and I think he had the specific number that he was famous for on his avatar, to use the word of the moment, in a EA Sport FIFA game. They had 15 editions of the game issued by EA Sports. He sued. He asked for 300,000 reais, so basically $50,000 in moral damage if we were to convert the money right now. He won. The court, in all instances, all the way to the Superior Court, assigned damages to his image, even though he wasn't the center of the game. He was just one of the players that you could have. His image was clearly used, and I think the highlight I would make on this case is that EA Sports had acquired or had paid and had obtained a license from the FIFPro, the Federal International Association of Professional Soccer Players, and it was a very well-written license agreement. However, even though the player himself was a member of this association, he never signed that specific document. So the interesting part of this specific case, first case, is that the court found that such a personal right cannot be assigned in general terms. So that makes it very hard if you're thinking, globally, to assign and to license, better said, a license image rights or publicity rights or right of publicity globally. You really have to be more careful about the risk that you're taking with this type of global assignment, union assignment, or even club assignment. And the courts do not find reasonable to accept that this union had the power to assign a image rights to a video game in perpetuity, pretty much. I think the tough part here, and that's my feeling, because we advise a lot of image right holders and their supporters, their brands, is that the damage is really, really low. The amount at the end of the day, like I said, $35,000 for 15 editions of this game is what the player asked for, and the court said, no, your image was not used in a bad way. In fact, and I truly hate this thinking, but your persona was actually escalated to a different level internationally, and I think that's quite contrary to the principle of an individual right, a constitutional right that, you're doing me a favor of exploiting my image. And the court assigned a 5,000 reais, so basically $1,000 per edition in moral rights. So at the end of the day, black and white, it would be an infringement of its right, of the player's right, but when you're talking about counseling your clients, you have to know that, at least in Brazil, the damage is not going to be that significant anyway. Do you want to hit the next for me? This is basically, that's okay. Basically the same situation, also with the EA Sports. These cases are leading cases in terms of image rights infringement in Brazil. I made basically the same comments, if you can hit one more for me. And then the next one is, I just learned this term today in Spanish, so I'll use it. It's the figuritas, of the Copa do Mundo.
Figurinhas.
Figurinhas, yes. For a famous soccer team in Brazil, Flamengo. And this player also sued, also asked for indemnification for use of his image, and only got 7,000 reais per edition of the album. So again, this just shows that in terms of whether it's an infringement, I think it's going to be very clear that if you're going to use someone's image, persona, or characteristic at all in publicity and advertising or any commercial platform, you're probably going to be found to be infringing. But at the end of the day, the cost of that may be worth the game. So,
Thank you so much. And what about the U.S., Miguel? Can you share with us?
Well, nosotros tenemos un caso con Jordan que es un parteaguas.
We have a case with Jordan, who is a water breaking or a water separator. The interpretation that the courts make, this was in the 7th District, the interpretation that the courts made around the right of publicity or that right to obtain some profit.
To the Jordan case, I just want to mention that it's funny because 100 years before, that's what the court said about Miss Robertson, that if any, she was being rewarded because the flower bag made them famous. So there was no damage, totally the opposite. But we're talking about a different time.
I find this case, if I can go deeper, a little confusing because they don't assign any monetary damage. So technically, the damage for him was only moral.
Yeah.
But when it comes to moral, it's not that big of a deal either. So if it's not monetary damage and it's not a big deal moral, what is the damage? Well, how do you assign that? Like, how do you attribute? So I think it's a little, I don't know. It's on the wrong side of the spectrum, in my humble opinion.
Yeah, well, 100 years ago, there were no moral rights, and neither now. It's all about money.
Right.
It's economical.
Yeah.
En el caso de Jordan, precisamente.
And in the case of Jordan, precisely, Jordan, his induction into the Hall of Fame was done in 1995. And to commemorate this edition, Sports Illustrated pulled out a special edition. And they recruited some department stores and some supermarkets within the area of Chicago, which are recognized for having a certain identity with the city and with the team of Bulls where Jordan used to play. And the treatment that Sports Illustrated made with this was that, well, first of all, it was 2 supermarkets. One was Dominic's and the other one was Durrell, I don't remember very well. But they made an agreement where they didn't have to pay for the advertisement, but they have to limit themselves to congratulate Michael Jordan and just exhibit the magazines in their supermarket within their shelves. Now, Jordan, who by that time was already known as a prolific, litigious person, he immediately demanded, and the defense that was used specifically for Yule was the First Amendment. And just as we spoke before, there's a constitutional right to express however you want, and there was no commercial profit in this case. What makes this case different and what makes it like a separator is that the court makes a difference between what commercial speech is, which is the commercial expression through which a third party may obtain an earning because they invite to a transaction when they use the image of the sportsman. And what's the improvement of the image? So they now distinguish between the right that each athlete or individual have, or in this case, Michael Jordan, in terms of the usage of the commercial image of the commercial usage of his image, which was already recognized in statutes or illegally in Illinois. And there was another right, a new right, well, not a new right, but it was a novelty kind of usage, which was the right to control, not necessarily to obtain any profit, but to control the way in which that profit is obtained. Now, with this distinguishment, the arguments of Jordan were that my image has a determined commercial value, and I don't want it to be linked to a supermarket, least to a steak, because I'm in the steak business. By that time, Michael Jordan already had a steakhouse with his own name. With this distinguishment, he insisted in the court, and this was not the case of Jewel, because they made a litigation that was so long that this was solved 10 years later in 2015, because they appealed, going back to court, and well, towards the end they got a settlement, but it was solved. In the case of Dominic, with the case of a sentence of $9 million against a supermarket, $9 million. And how did the court arrive to this quantity? It was through the evidence of how much Michael Jordan was charging to make an endorsement, a sponsorship, or to make an advertising. And after they admitted the sentence for Jewel, they got to an agreement. I do not know how much was the quantity, but eventually it should have been some hundreds of thousands of dollars, probably millions. And as an anecdote, we know that the damages that Michael Jordan recovered were donated to institutions of charity within the Chicago area. So I believe that the lesson that we can take with us is that in the United States, this concept of right of publicity has become so sophisticated that it is not limited into the athlete to claim those profits that were obtained by the company that in a non-authorized way used his image, but also you will have some punitive damages because it deprived him of his right to control the way in which those images could be exploited.
To control, because that's
a good
very
point.
much what it sounds like. It's maybe the U.S. doesn't like to say moral rights for some reason, doctrine reason, but it feels like, okay, I'll give you some moral rights here so you can control. That is pretty much the...
It might,
Right?
yeah, it might have some parallels, but it's not the concept that the courts are
Right,
using.
right. They didn't use
Yeah.
that word, but it
Yeah.
sounds like a...
Yeah,
a
well,
drop
there
of
is
it.
moral clauses
Right.
that we will discuss a little bit ahead, but as a concept, as a legal concept, it's not something that has been embraced
Right.
by courts.
Right.
Again, maybe this is a little bit crude, but everything that goes around economic incentives, punitive damages related to how much that image would be valued. But I think moral rights would be I'm gonna use it in my next script.
Thank you, Miguel. Thank you, Fernanda. And what about qué hay con la trans?
Thank you, Miguel and Fernanda. And what about the transaction? What happens in the reality? What can you tell us about how this operates at a transactional level? Well, in sports, let's say that the sports right is not a codification, a specific codification. It's the amalgam or the tensions that happen within coming together entities that are linked to the laws of the territories where they are located, as well as they are subject to rules of a private figure, to all these rules and normativities of these sports entities that to which they are affiliated. In this sense, the sports right cannot go into the terrain of these concepts and define some criteria, because towards the end these are topics that depend on the applicable law in the territory where the person is or in the company or entity. Therefore, in the sports entity, they will be subject to whatever happens in each territory. Let's say that the sports organizations may limit, with the purpose of protecting their product or making it more appealing and attractive for the sponsors and brands, and they could also restrict the exhibition of brands, but they cannot get up to a point where they start taking decisions or start promoting laws around these kind of topics, because these are issues that have a legal character nationally or supranational, but in a public environment or surroundings. So retaking these transactions, these real cases, and precisely this topic of Michael Jordan, I don't know if you all know what happened some years before that demonstrate that Jordan was effectively very conscious of his image usage, and despite in this case there was no damaging consequence in terms of the fulfillment of a contract or anything. I believe this was more like a gesture of loyalty to his brand. Jordan has one of the most expensive contracts with Nike. So in the Olympic Games, each sport has their supplier of clothing according to the local federation. In the United States, it was Champion, and with Champion there was no issue and there was no way to escape. Jordan was going to use the shirt or the sportswear of Champion next to all his partners, but at the moment of receiving the prize, the clothing that he had to use was not the one of the Basketball Federation, but the one of the Olympic Committee of the United States. In that case was Reebok. And in that time, Reebok was a ferocious competitor to Nike. So Jordan, and as a matter of fact, all of those that had a contract with Nike, what they did was that they opened their jacket or their hoodie, however you call it in your different countries, in the sense that the emblem of Reebok that was here in the chest would not be seen. And Jordan said, I'm going to take a step ahead in a way that they cannot say anything. And he put the flag on his right shoulder, and he covered the logo of his hoodie as well as the one of the pants. And if his other colleagues had that logo, he seemed very patriotic, Jordan, and in this very kind of wise way, he didn't have any inconvenience. But I'm sure that the people of Nike were more than happy, and of course he must have thought that they were going to recognize that good gesture that he had. That's just to take the case of Jordan. And going into new topics, approaching from 74, when all of this was so new and there was not so much knowledge around, we get to Kylian Mbappé, one of the best, undoubtedly, players in the world, perhaps the best, who is right now doing great things in the World Cup. And so this is this year, not from a long time ago. It's not like there weren't more rights so long ago. No, with everything we know, everything that is known, all of the experts who advise an entity of the magnitude and importance of the French Federation, this incident takes place. The players of the French Federation, the select team, when they go to games of the French selection, they have a document subscribed, virtue of which they receive a certain provision, and the association has the right to use their image with the sponsors. And so here, you don't just have the agreement of the federation with the player, but by virtue of that agreement, the French Federation tells the sponsors that you'll have the right in those contracts of millions of euros. Since I think in euros, so in euros the number isn't so large, but it's a great number, so $1 million contracts. And so you'll be able to use the image of Kylian Mbappé, and that sounds great, right? They pay a great amount. They have a great contract with all of the provisions of the case, but then Kylian comes and makes that face and says, I don't know if I want my brand for those 25,000 euros. If it should be connected to my image be connected with fast food brands, with betting brands, and businesses that frankly I don't want, and I don't want my brand and my image to be associated to those types of activities. And so, as I said, contractually speaking, there isn't a lot that can be done, but then this brings us to the consideration of the importance of the athlete. Surely this can be resolved, and there are does the French Federation want to enter a conflict with its best player? Do the sponsors want to have Mbappé unhappy? This is even above what great lawyers and specialists on these subjects, beyond what anything they can foresee. There will continue to be a moral situation to resolve. Not all athletes will have that power of decision or that level of influence, but Kylian Mbappé said it. It's not because of the money. Everything that I gain from my games with the national team goes to charity, but it's not so much about
this being a competence of my steakhouse or me not liking it or being above it. I just don't agree. My principles, my morals tell me that I wouldn't want to promote these types of businesses, such so that there was a lot of tension. Kylian Mbappé had left a photo session with some sponsors in 2022, some months ago, and in September, when this case takes place, the French Federation carries out all types of actions to try to convince him. He says no. He had already said he wouldn't participate, and the French Federation emits a communication saying that they commit to revise that agreement with the players, founded on concerns and legitimate conditions manifested by the players. Unanimously, the memo doesn't say it, but they don't mention Mbappé, but it was the most important player saying this has to change, and the federation commits to changing it, and through this commitment, Kylian Mbappé decides to participate in those promotional activities. And so this was done with the commitment to change. And so current transactions like this one, there will be many, but always subject to the fact that we are speaking about a person who has certain ideas and a vocation, and that can say no with their influence and the importance that they have in the world of sports. Perfect. Thank you, Felipe. And what happens when there's a misstep, whether it's from the sponsor or the athlete? What impact does this have? Because they contribute with their image and their goodwill. What happens when there is a misstep? Well, the first thing is, this is just to highlight here, we've seen that despite the evolution we've seen, there is still that possibility that athletes can impose their will, and that implies to them a very large responsibility. If you look, athletes have moral standards to follow that we don't even require from our politicians. Or they can't drink, they can't make mistakes, they can't be disrespectful, they can't get angry. All of this has an impact on their image and the images of the sponsors in this regard. This has more of a historic development, that the athletes have to follow very strict parameters of conduct so as not to impact the image of their teams. A recent case of a Colombian cyclist, Nairo Quintana, who a positive result for a substance that is not considered doping. It's not in the list of prohibited substances, but the International Union had prohibited this substance due to the effects that it has. They reduce pain, but they can also they can cause dizziness and their ability to impact their ability to focus. And a cyclist moving at 90 kilometers per hour, this isn't ideal. And so in order to prevent risk or danger, the cycling union prohibits this. So it's not doping, but still Nairo Quintana gets evaluated and it's positive, and so he is disqualified from the Tour de France, which where he was just finishing in 6th place, which was a great achievement considering his age and the difficulty of the competition. This led to a set of huge problems because it puts into doubt his honesty and transparency as an athlete. The contracts foresee termination in case of doping, but this wasn't doping, and so the team did not have a solution in this manner. So we had the coincidence that this situation took place right at the end of Nairo Quintana's contract, and so they just didn't renovate his contract, when in the media they had said that there was an agreement to renew it, and so now Nairo is in trouble in finding a team so that he might maintain his sponsorships. And so in this sense, it's common for athletes to be subject to a standard, but we've also talked about this with Miguel, that athletes can also be affected by the behaviors of their sponsors themselves. And what this slide talked about was that very thing. And for high performance athletes, there's been revenue and royalties for the use of their image that are even greater than the salaries that they make for their actual sports activity. But beyond those elevated revenues, there is an issue when those companies who are willing to pay such money also have a bad behavior. And so in that regard, I wanted to speak, Miguel, because I know you have an interesting recent case. It might be incredible, but despite everything that we're used to knowing about standards and development, the vision and commercial strategies are always a step ahead of the law even. And so we propose something, and while we're adapting to that new trend, there are already cases happening like what I'm asking Miguel to share with you. Thank you, Felipe. What is the name of this painkiller that the cyclist used? Tramadol. After 4 days party, tramadol. That's what I'm going to look for, right? And football team. Not joking. It's real. So this isn't a precedent. Frankly, it's a hypothesis. It has to do with the concept of mutuality in these clauses that we normally find in endorsement. Typically, an endorsement contract will include a moral clause where the athlete is obligated to carry an irreproachable behavior. In a list of instances in which the athlete could be maybe not complying with this, and the consequences of this, which go from the suspension of the contract, the termination of contract, and in some cases indemnizations against the sponsor contractor who pays the athlete. I've thought recently these contracts often include a concept of mutuality in their moral clauses, where not only is it the player who must exhibit an irreproachable behavior, but also the sponsor must be aligned with certain values, principles, and matters relating to ESG, and this is a corporate concept which basically has become standard today. Some weeks ago, an exchange market, a crypto exchange, which I think is popular, known as FTX, we all got to know them through their ads during the Super Bowl. FTX declared insolvent and then bankrupt, and there's a suspicion of fraud. Those who have called it a Ponzi scheme, which is nothing more than a pyramid, a fraudulent pyramid, and the new Enron, the new Madoff, and there's an idea, a negative idea, with regards to the use of the resources and clients, the disappearance of millions of dollars that are still not found even after the audit of their bankruptcy. And Tom Brady was intimately connected to this company. Not long after the announcement of insolvency and the suspicion of poor management of this company, a lawsuit arises in Florida where one of the users, it's a class action, a collective action, in representation of many other, and at the same time, this takes Brady and Giselle, who are together now, and Steph Curry, who was also a recognized athlete, who did some promotion for this company. The point I want to get to is I have a lot of, I'm very curious in reading that clause between FTX and Tom Brady, because I think the ones who will pay, one who will pay will end up being Tom Brady. His image is devalued due to their association to a Ponzi scheme like this, or that's what's alleged at least. And if we had to give this a number, Tom Brady isn't just paying the 20 million that he was compensated with for making these Super Bowl commercials and equity in the company, but surely it will be, if you'll allow me, it's a stain that Brady will live with even after the end of his career as an athlete. And so this concept of mutuality that we see recently and more frequently in sponsorship and endorsement contracts, I think will end up becoming a necessary clause or a mandatory clause, especially to those representing the athlete in this case.
I didn't see the FTX contract whatsoever, but we represent a communication agency that hires influencers to match with their advertisers. And you'd be surprised. I mean, the influencers are top A influencers in Brazil, but they're not Tom Brady, obviously. And there is no mutuality whatsoever in the contract. The advertiser happens to be, and that's why it came to my head, a cryptocurrency exchange company as well. And the whole contract favors the advertiser, not the influencer. And I think the point I thought it was interesting to make is, I think more and more in a world of influencers, in a world of virtual and digital influencers, I think people are not just athletes, which I think that's where we were 10 years ago, 8 years ago, but more and more celebrities and influencers in a broad way are paying attention to these type of clauses and contracts and realizing there's a huge opportunity to monetize, but the same big opportunity comes with a huge risk. So not signing a contract, not controlling that relationship with the advertiser you're sponsoring and endorsing, it also comes with the risk. So in this one specific contract, there was not whatsoever mutuality. So if this crypto brand goes down, so goes down the reputation of 10 stars that endorsed it. Talking about crypto.
Bueno, es interesante esto porque, como les decía, va un paso adelante la estrategia.
This is interesting. Yes, the commercial strategy is always a step ahead with regards to the clauses of the contract and the provisions that we can perform. And the clubs are connected to the NFTs, and we're always looking for references and saying that this club in Europe did it, Juventus, Paris, and so this company is legitimate, but it doesn't fully give us peace of mind, and so we do some due diligence, but there is no precedent, there's nothing to give us full tranquility, and so we've had to be very careful and wait, because these types of things are happening. These companies that seem so solid, and well, they talk to you about things that you don't quite know so well, and there's a tendency to just believe. I know Fernanda has a background and more knowledge on NFTs than I do, and so I'll ask for your opinion, of course, but one of the requests made by a company was seeking to create NFTs for the players. We wanted to have a session, or they wanted us to license, because the image in Colombia is also associated to intimacy, a good name, and honor, and so it's not easy to obtain those kinds of licenses, and they were asking that that image be given to them in perpetuity, because that NFT will be interchangeable and there will be a buyer who will have it and paid for it, and they have the right to have it forever. And we told them, well, if the player agrees, because this is personal, of course, we have to speak to each of them, there isn't a collective negotiation, when it comes to image. If the player agrees, we'll have the right to use their image during the contract. We can guarantee this if the player allows it for 1, maybe 3 years, and then we can't guarantee the use of that image. So this company insisted that it had to be in perpetuity, and we said, no, thank you, but no. So I don't know, Fernanda, what you think of that, but we do get these types of offers more and more, and there's still a whole universe to see, the metaverse and NFTs.
You mentioned that, you have to have a very clear view of what is the rights that you are signing or licensing. Under a right of publicity spectrum, you may license as well, but in a situation like in Brazil, or a civil law jurisdiction like in Brazil, you have to be a lot more careful, more conservative what you're thinking, what you're considering. I have very little to add other than, yes, image rights can be used even for takedown of NFTs, infringing NFTs. We've seen that, but it's not so easy. And I think the influencers, the athletes, the industry, it's not yet mature to just assign, license, and commercialize their image rights to NFTs because they don't know the whole spectrum of what that means. They just think, okay, there's a lot of money in the game here, I'm just gonna do it. But they don't realize that 10 years from now, that same image may be out there and you're not happy anymore with how it's going. So.
Thank you so much.
Thank you.
To each of you. This has been our panel. No sé si alguien quisiera hacer alguna pregunta. Aprovechen porque...
I don't know if anyone has a question, since we have Idala.
I'll make a Portuguese question to Fernanda. Fernanda, oi. A gente sabe que a Constituição brasileira, ela tem, apesar de ter mais de 30 anos, ela é bem visionária. E ela fala bastante dessa questão de privacidade, de direito autoral, de direito à imagem. E a gente sabe que alguns direitos são limitados por outros, claro, e tem a questão da informação, de coisas históricas sobre a imagem dos jogadores. E a gente sabe que o Brasil tem no DNA o futebol, e hoje em dia eu fico perguntando assim, os museus estão sendo totalmente digitalizados, não só do futebol, mas de outras áreas também. E a gente sabe que existem as imagens de cunho histórico relacionadas aos jogadores de futebol, etc. Você acha que, diferentemente de museus físicos, que tinham uma limitação, um enriquecimento mais limitado, os online, eles têm um enriquecimento sem você ter que saber até que ponto vai chegar. Você acha que, em certo momento, vai ter um conflito entre a questão histórica, informativa, e esse lucro sem medidas, que os jogadores vão poder demandar um novo tipo de contrato para um novo tipo de uso de imagem? Obrigada.
Obrigada pela pergunta. I'm going to answer in English just for everybody's benefit, I guess. That's a very interesting point, because one of the cases that I showed regarding the figuritas, the defense of the editor, the publisher of the album, is that it wasn't a commercial use of that player's image. It was actually a biographic, gathering of players' information. It wasn't a cup album. It was a team. It's actually my team, Flamengo's team, 100 years of history, and they were putting together this figuritas album with the data and the information, when that player played in Flamengo and so on and so forth. So the defense was, this is a First Amendment kind of views of your image. And the courts found that, nah, not really. You're selling the figurinhas specifically. You're selling the album. And yes, you can probably make the point that, look, a museum, you're paying the ticket to go in, but it's a lot different than having, a picture or a figurinha or a sticker with someone's face and making that your product. And I think the point I wanted to make as to where we are going with this, I think the more the image itself is the value of the it that you're buying, the less likely you're going to have the defense of information or freedom of speech or whatever, the more, and that's the line of the NFTs. The NFT, you can claim, look, I'm just using your image for information purpose. I'm just selling an art based on your face. Well, it goes up to page 2, but now that you can sell the NFT over and over and over and monetize that forever, maybe there's a better case for image rights than we used to have before. Does that make sense?
Yes. Y esto es muy similar a la defensa que trató de utilizar.
Yes, and this is similar to the defense that we try to use when it comes to the store or the supermarket that was congratulating Michael Jordan for their induction to the Hall of Fame. And they say that there isn't a commercial use because there isn't a transaction happening. And this is where the Innova court says it's not necessary that you inherit a transaction. You're obtaining a benefit because your supermarket brand seems to be associating to Michael Jordan and to the achievements that Michael Jordan has had. And so there is an improvement of that relation. And so although the First Amendment defense is very common in case of violations to right of publicity, it becomes tighter and tighter, the more complicated the way that we can use that. Thank you both. Do we have time for a couple more questions? It seems there are no more questions. So in this case, Luis? Thank you. Good afternoon. And thank you for all of the cases we've heard. I wanted to know if, from the perspective of the different jurisdictions that have been addressed, if there's the right to revoke, as in many cases these rights have an economic purpose. Sometimes people change opinions. I remember a case in Spain of, in this case, a singer who made, the name of the group was used for the sale or commercialization of burgers. At the beginning this person didn't care, but then they became a vegetarian, and what was initially a consent was later revoked, and they stopped the commercialization of that announcement because their ideals had changed. And I wanted to know if this also exists in other jurisdictions.
Personal right, you can definitely revoke. Whether the contract is going to impose, a consequence to that as a breach is a different story, but in principle, yeah.
Esa es una muy buena pregunta. That's with a Dallas Maverick player. Este jugador es un jugador.
This player is a very well-known player, except I don't remember his name, but he played for Madrid. He is from Slovenia. His name is Luka Doncic. And then he arrives to play for the Dallas Mavericks. Or is it Jokic? Okay. Him, exactly. He provides his consent for the register of a brand, and the brand was this was done through his manager when he arrives. A year ago, he is distanced from his mother, and he's contracted by or hired by a representation company, giving him incredible deals, and he's fighting to remove the consent that he provided for the brand registration that his mother has, which is still valid. That registration she can still preserve for the next 8 years, plus the renewals that arise as the use continues. It is not yet defined. The dispute is in the administrative personnel, TAD, but my suspicion is that from there it'll go to an appeals court. But that, I think, is a very relevant question, particularly in the United States. I just wanted to ask Luis, because I don't know how that revocation right functions. But Fernanda says that's the matter here. That right can be exercised without generating consequences for the exercise. Because of course you can revoke, but then you will have to pay. And so I wonder if in your jurisdiction, in Spain I assume, this would be without patrimonial consequence to those who exercise that right. So based on the organic law to property of image, and indeed when there is, when someone revokes, the first thing that can be done is request an economic compensation for the damages that this can cause, and so revocation is not free. Now, of course, if upon establishing a contract relationship we assign the right to revocation without compensation, then there would be no problem. But where there is not a contractual relation, indemnization can be requested now by judicial means. This sometimes sets people back when it comes to filing claims due to the costs that this will bring. It's a costly procedure. Thank you, Luis. Do we still have time for a question? Mr. President of the Brand Community, my boss. Thank you for such an interesting panel. This is mostly a practical question to see how are we going to begin to negotiate with influencers and communicate with brands and propose this product. And what do you suppose we'll have to try to achieve with those influencers or athletes or well-known people who in upcoming contracts? How do we protect them if we associate them with a product? To improve the sport, but it turns out that they are bad supplements or they have a problem. How do you see, in practical terms, how do we start to protect them within these contracts? This has a little bit to do with what the Tom Brady case. If you associate Tom Brady to a financial advisor, you understand that they show up in a commercial and they think that that's it. How do we see this for the future? Even podcasters who are making publicity for so many products, how do we see this for the future? Creo que puedo comentar primero. La Junta Regulatoria definitivamente asigna alguna responsabilidad al influencer. No pueden simplemente decir, esto fue lo que me dijeron que hiciera y pensé que el gummy era bueno para mi cabello y nunca lo probé, nunca lo utilicé. No, pero la Junta no asigna o da penalidades monetarias. Es una decisión o recomendación que a menudo es pasada por las agencias de protección al consumidor y terminan demandando al influencer y a la marca. La consecuencia está ahí. Y con respecto a tu punto acerca del contrato y el punto de la mutualidad, trabajo mucho con estos tipos de contratos y lentamente, pero definitivamente, el mercado de influencers en Brasil específicamente se está madurando. Y la palabra que suelo utilizar es que es un contrato de talento. Y no es solamente cuestión de que toma el gummy, $30,000 y 30 segundos de mi historia o mis TikTok. Pero es la mayoría. Pero a causa del caso FTX y otros casos de situaciones reputacionales, que no vale la pena el riesgo. Solo sé de un caso en Brasil, como corte pequeña, de un mal juicio para un influencer para que pagara el teléfono que un seguidor obtuvo de un fraude porque ella hizo la publicidad. Ella dijo, mira, compra esto con este, y nadie recibió el teléfono que supuestamente compraron. Ese ha sido el único caso que conozco en Brasil, pero en cuanto a contratos sé que definitivamente son más cuidadosos ahora. Tal vez no tanto como quisiéramos, pero deben alinearse con lo que están publicitando, porque eso es básicamente lo que hacen en una forma diferente, pero lo mismo. And just to complete Fernanda's idea beyond the regulatory framework for marketing campaigns, which is a vast world in the United States, I think everything is reduced to the power of negotiation that the celebrity has. Because within a contract, and this comes to mind, normally I take the side of the sponsor of the company, and I think the side of the athlete and the influencer, you have to work on the clause for limitation of responsibility, or limited liability, work on the clause for insurance. You could find an umbrella policy for both. You have to work on the clause for intellectual property, because there will be cases where the influencer specifically will contribute with some intellectual creations that may be subject to some sort of protection, copyright and others. And of course you have to work on the mutuality of the moral clause. And so this is what comes to mind that I think should be negotiated by these influencers.
Que habrá muchas compañías que
Yes.
te van a decir, take it or leave it.
Yeah. Wasn't there a case of Molly Sims who infringement when she advertised a brand in the U.S., a makeup brand that was being, wasn't there a case like that, that she, because she was the collab
Yeah.
influencer, and then I think there's a case out there where she was sued for the trademark infringement and liability.
I don't have it at the top of my
Maybe,
mind,
yeah.
but there is a new one, and it involves NFTs. Hay un nuevo caso que involucra temas de NFTs y música.
Now, there's a new case involving NFTs in music where there's a contribution recognized, at least in terms of what is known as moral rights. But speaking of this perpetual transmission of the NFT, they weren't paid after the first transaction, and the contract does not touch on that type of transaction, future transactions after the first one. I wanted to add, since you were talking about how this could have impacts on certain substances, my focus is always sports, and so I was thinking about how an athlete could use that defense in the case of getting positive results on a test, but there's an objective responsibility that the athlete is responsible for what enters their organism and preventing that these things don't happen. And so it's almost like the burden of proof is almost inverted, and so I don't see it as a successful defense. Very well, so thank you. We are right on time. We actually went over it a few minutes, but I wish you success, and thank you for the content, and thank you for being here and answering your questions and for your time. It's been a privilege. And thanks to all of you for coming.